This podcast is sponsored by Quartz IP. For more than 20 years, the PracticeLink IP operations platform has helped some of the largest IP practices in the U.S. simplify and scale high-volume IP operations. PracticeLink is designed by IP teams for IP teams, bringing smart automation to mail intake, calendar management, and client communication while making sure service to your clients still feels personal. Learn how Quartz IP drives excellence in IP operations at quartzip.com.
Hello, everyone. Welcome to IPWatchdog Unleashed, where each week we journey into the world of intellectual property to discuss the laws, news, policy, and politics of innovation, technology, and creativity. With analysis and commentary from industry thought leaders and newsmakers from around the world, IPWatchdog Unleashed is hosted by world-renowned patent attorney and the founder of IPWatchdog.com, Quinn, who has twice been named one of the most influential people in the intellectual property community and recognized numerous times as one of the top IP strategists in the world. Take it away, Gene.
Thanks, Renee, and welcome everyone to this week's edition of IPWatchdog Unleashed. This week, our guest is Alden Abbott, and Alden is currently Senior Research Fellow at the Mercatus Center at George Mason University. In that position, he oversees research on antitrust and competition policy, and that is where he is an expert. He's also an expert on the intersection of antitrust, competition, and intellectual property. Alden has also served, prior to being at the Mercatus Center, he served as General Counsel at the Federal Trade Commission, and prior to that, he held senior legal management positions at the Heritage Foundation and BlackBerry. Alden has also previously served in a number of roles in the federal government, including at the FTC, Commerce Department, Justice Department, and Alden is, in my opinion, one of the preeminent scholars in the area of legal economics, and he's one of the few legal scholars that appreciates intellectual property, and it's been a great honor to get to know him over the last, well, it's more than a decade now. We've been friends, Alden, and thanks for being here.
Well, thank you, Gene, and you and Renee have done a fantastic job in building IP Watchdog into sort of the preeminent site and conference convener on IP policy matters. So hats off to you.
Well, thank you. Thank you. I still remember, and this will probably maybe come up a little bit later on in our conversation. I remember when you first reached out to me, you were doing some stuff at the Heritage Foundation, and you had a working group there. And when I got invited to come to Heritage, I thought, wow, this is really special, and I've always appreciated that about you being very inclusive and of everyone in the community, regardless of political affiliation. Because in the IP world, we are all IP folks first, and then party affiliation always comes a distant second.
Well, that's absolutely true, and I think that's certainly been the case. As the all your conferences really bring together people interested in intellectual property from really a diversity of backgrounds. They all work brilliantly, in my view.
Let's take a step back before we jump into some of the topics that we wanted to really talk about today, and let the audience know a little bit more about you. I mean, we've been friends for a long time now, so I know your story, but can you tell us how you got into law to begin with, and then how you got into intellectual property and competition policy and antitrust specifically? So to start wherever you want to start with that story, if you will.
Okay, well, ages ago on the planet far away, I actually started out as a math major, then decided to become an econ major because I felt it was getting hard to prove all of these complex theorems. But anyway, I ended up thinking I was going to become an academic economist, but I had friends going to law school, and so I ended up going to law school and did some grad econ there. That was up at Harvard, and sort of I had gotten I studied antitrust a bit as an undergraduate, then economic regulation, and then antitrust in law school. But we heard very little about patents. This was back in the 1970s, and people did not talk about them much. But then later on, I was really in my third job in the early 80s. I was in the Justice Department, and I got to work with a man named Tad Lipsky, who was had come in with a Reagan team to be a deputy head of the Antitrust Division, which manages the Justice Department's antitrust cases. And they had new leadership, which was very free market oriented and skeptical about some doctrine that they thought overly constrained companies. And this was certainly true in patent area. This guy Lipsky asked me, and very kindly, to serve on some interagency working groups because he believed strongly in patent. He had the patents. He had an econ and actually physics background, and so he appreciated hard science. And I got to meet a guy named Jerry Mossinghoff, who was head of this interagency working group. He was head of the patent office, I think electrical engineer. I think had been chief patent counsel, perhaps at GE, but had a distinguished background. And he was very politically adept at getting people from different agencies and sort of using his allies in the Justice Department leadership to say, "Hey, agencies from uh, Commerce, HHS, on when you see patents, you really should not discriminate against them. You should be pro-patent and pro-patent licensing," which was a view coming out of the Justice Department. He also worked. There was something called the Semiconductor Chip Design Protection Act, which was in part drafted by the sort of interagency group and was passed in the early 80s, same time that the Bayh-Dole Act, which, as we know, sort of
Mhm.
unleashed the exploitation of patents at universities because it allowed private parties to hold patents on research done at government labs. All of that sort of came together, and I found patent policy and law very interesting because it fit in with what I had studied about economics and a sort of free market oriented and said, "Hey, this is property right. It's a way to drive innovation." And then later on, I spent a lot of time in and out of the government, but actually in the Commerce Department, I had the opportunity to work in management role as sort of a liaison between Maine Commerce and the Patent and Trademark Office, appellate people. And also, I met a couple of commissioners who were working on reports on the future of patent policy, and that was during basically the 90s when the pro-patent period was really still in ascendance. And, really, later on, I went back to the management job in the Federal Trade Commission where patents were being discussed. And then at BlackBerry Heritage, and then later on, General Counsel of the Federal Trade Commission. All this time, basically, coming back into government, in the 2000s, I tried very hard wherever I was to get people to realize the importance of patent rights. Sometimes I didn't win the bureaucratic fights, unfortunately, but that happens sometimes. But had the great fortune of being able to keep in contact with people like at the PTO and so forth, who there's a guy named Mike Kirk, who was for a long time a senior PTO, head of their international policy office, and later, I think, executive director of the IPLA I
Mhm.
befriended, and he was a great guy also. So it's really certainly a more than a bit of luck, but also meeting people who were very supportive of me and who were very interested in patents. And as I say, I would have never guessed it because before the Reagan period, patents really took a back seat everywhere. In fact, when I was in law school, they didn't even offer a course in patent law at Harvard, as if it didn't matter, which was crazy. But that's the way things were.
Yeah, and sometimes I wonder whether we're heading back in that direction. I mean, it's not nearly as bad as it was at that point in time, right? I mean, we had the 9 no-nos, right? It was and there was this idea that patents were just evil. They were per se monopolies. Everybody knows it. Patents are just bad for everyone. And we have totally done a 180. And now I wonder whether we're slipping backwards because there is this belief, certainly on the injunction side at least, that patents get in the way, and that was what just pervaded economic thinking for so long, and I don't understand how we can get something so right and then slide backwards, but that seems to be what I see happening. What do you think?
Well, I think that's a real risk. And part of it is, you know, let's look at the Supreme Court in 1980, 81. the Chakrabarty decision was really big because the Supreme Court recognized that basically a engineered bacterium could be patentable. It wasn't in just purely from nature. It had been engineered, and that drove, I think, a lot of bio research and later pharmaceutical research into the U.S. with companies establishing headquarters. And clearly, the patent law drafted in 1950, I think Giles Rich, later Judge Giles Rich, was so important, had Section 101 basically said, of course, you had to have, was this the original? Did it advance state of the art? Was it non-obvious? Those tests. But basically, the basics of the patent law 101 said anything under the sun is patentable. I mean, that's a slight exaggeration, basically, and that seemed to be the case after Chakraborty. But I think part of it is that and I saw this in the early 2000s at the FTC, some theoretical economists started writing these theoretical articles about how patents could distort markets after all and were dubious and that they could slow down innovation, which I think was the opposite. And I think it's the Supreme Court in 2006 started down a bad road with its eBay decision. And actually, it was really the concurrence, not the majority opinion, but the Kennedy's concurrence, which later said, "Hey, you don't have presumed injunction if there's a holding of patent infringement. You have to weigh these four factors." And there was an even more negative tone to the concurrence that made it much more difficult. Lower courts interpreted that as a sort of a break, as we see on patents, on protecting patent rights after infringement. And at that same time, then from starting around 2010 and 11, as you and other people may know, Supreme Court issued a variety of opinions. I'm not going to go into that, which really weakened the underpinnings of 101. That made it create a new uncertainty as to what was patentable. And then many years ago, later in the oil states opinion, they even cast some cloud on whether patent right was a full property right instead of sort of a license granted by government. Of course, the patent statute comes out of a constitutional provision, but it's from the Constitution, but it had never been thought. The statute says it's a property right. I think before that Supreme Court decision, we thought, well, this is a property right, but how do we constrain it? Now, if you view it as sort of more a government license, and the government has property to modify it, that undermines the whole idea. So I think you had these legal things happening. Some of it was pushed by scholars who, whether they were paid or not by a certain interest, I'm not going to speculate, but some of the scholarly work, I think, infected the courts to some extent, and that was a bad thing. Now, uh, the old saying, "Your history doesn't repeat itself, but it rhymes." If you had a cycle really from I think 1890 to 1930, patent rights were respected by the courts, were strong. Then from about the 1930s till about 1980, it was sort of the anti-patent period. Talked about nine no-nos, even all sorts of patent licensing arrangements were viewed as troublesome, problematic, even if the arrangements were just allowing the patent holder to earn a return within the scope of its patent and within the time period of its patent. So those were very strange holdings. But then again, new law and economics came in, and from the 80s till about the early 2000s, we had a pro-patent period. Then things really got crazy. There was, I think, the Bush administration first and second Bush administration, it was a bit of a negative view at the FTC, but not the Justice Department. In fact, they clashed a bit. Then under the Obama administration, both FTC and Justice Department started being more questionable about patents, going after patent settlements. I won't go into details where payment is made by the patent holder, going after standard setting and trying to in effect regulate or hint how standards setting proceedings should be carried out, limiting standard essential patents, patents that read on standards, all of that seemed to be weakening things. But then the first Trump administration, very pro-patent, head of the Antitrust Division was a former patent lawyer, in fact, a Macon, Delaware team, and he said basically it's a strong property right. It should be protected. You have a right not to license. You have a right, even if your patent is a standard essential patent, to get a high return, contrary to what the last administration said. Well, we can limit the returns because it's monopolistic to let the holder of standard essential patents get too high of a return. So that was very good. Then again, talking about the cycles, it's like a sine wave that there's big waves and then they compress more and more and more. So the periods, the amplitude and the minimum get are smaller. Then the Biden administration anti-patent, even more so, I think, than the Obama administration. Then are things being restored? I think so to some extent, but we'll have to see what the courts say. And the person at the Antitrust Division, Dina Kalai, who's the Deputy Assistant Attorney General dealing with IP and international things for quite a few years, was a Chief Antitrust Counsel for Ericsson. And she very much realizes she had been at the FTC earlier, she very much realizes the importance of patent licensing, how valuable it is, and she's given speeches, and the Justice Department has made so-called statements of interest, like sort of like amicus briefs in private litigation, saying that we think standard essential patents should not be denigrated, that they should have a right, to go get injunctions like other patent holders. And she made Justice has made a number of other statements that I think are pro-patent. I would tell people are interested. There's a speech, March 25, 2026, on the Justice Department website, Office of Public Affairs, called Fueling Innovation, Antitrust, and Intellectual Property in Support of American Technological Leadership. And she says basically up front, actually, this is, March 25, 2026, a couple of months ago, that yes, she quotes the president, says that there's a recognition of the importance of innovation and these are the sorts of things we're filing. We also think that you should not tinker with statutes like Section 337 of the Tariff Act, which had been used to exclude to prevent exclusion of goods which had been produced without receiving overseas by parties who did not hold a patent license, patent in the US, imported, they were infringing the patent, and you could exclude, but there's this public policy exception. And the antitrust people were very anti-market in the Biden administration and said, well, this is an important exception. It's against public policy to let these standard set SEP holders get high returns. There may be a good argument in many cases to block these imports, not to block these imports, to allow them in, even though that is the primary remedy under this International Trade Commission statute. So, and in fact, it's saying you can ignore an important statutory remedy because we don't think certain kinds of patents deserve high returns. That's a crazy position, and that clearly is a position that I think is rejected. Now, what I am not don't have a crystal ball, but I think the positive thing is that at least there's a recognition once again in leadership. Even though there have been some critics on both sides, left and right of the Trump administration, but it seems to be getting technology right. And to be honest, as you mentioned, I think there's a bipartisan element. Senator Coons of Delaware, for example, and he is a Democrat, but he very much believes in strong patent policy. Congressman Massey, who's no longer going to be a congressman, he lost recently, and not a friend of the president's, but he also believed in very strong patent rights. So I think you see people of different, not all, but you see, I think the main thing seems to be do people realize the importance of patents to innovation. If people who have studied it, there's all sorts of research, and with a lot of it was cited by the former FTC chairwoman, Maureen Ohlhausen, that shows around the world an association of the stronger patent right regimes are associated with higher rates of innovation. And, the old saying, correlation does not imply causation, but there's a lot of reason, sort of natural experiments, when you strengthen patent rights in one place but not in another in some foreign jurisdictions where patent rights are being strengthened, innovation you get more investment, which is sort of common sense, and innovation may be expected to rise. So I think given the importance of international economy and economic uncertainty, the big thing that's necessary is to convince people. This is partly an educational people. Hey, patents aren't these just monopolies used to enrich a few bad cats. Patents are in fact very important, often for small businesses. In fact, it's lots of large platforms we know now have had patents, but they're not saying much at all that's pro-patent. They're sort of being quiet, but often the smaller inventor, the smaller firm, the smaller hopes to be able to use its patent to leverage that to either grow in the market or be acquired, and that's good. It encourages innovation. So the idea that is if you attack patents, that's not a problem. It is a problem. It actually discourages small inventors and small scale innovation, which can feed larger scale innovation. So sounds like I'm giving a sermon, but that's where I am.
Well, I think a lot of people will agree with you, and I'm glad you brought up the issue about uh, correlation does not imply causation, because I absolutely hate that saying. And when it gets used in our industry, dealing with our issues, what it is it's somebody who has literally zero evidence to support what it is that they're saying. And what they want to do is wave around some trite, ridiculous saying about, oh, correlation is not causation, is a way to erase all of the evidence that we have, because all of the evidence is on the pro patent side. I mean, there's not any evidence on the other side. Everywhere that patent rights have been strong, innovation has gone up, investment has gone up. It's across the board. It's easy to see. We also see things like when price controls get enacted. There is less access to medicines, for example, in countries that do that, and it's just across the board. And they say that uh, correlation is not causation because they want to ignore all of the evidence that we have, and then they then pretend that, well, we have won the argument because we've erased all your evidence. Well, you can't win an argument if you don't have any evidence yourself. And I also think a big piece of this, there is no accepted definition of the word innovation. We are talking past each other at the very beginning here. So innovation in my mind is something that is new, something that has not ever before happened. And when you look at the big implementers, they consider innovation as something that they are doing for the first time. It's innovative for us to be doing this. We've never offered this service, so it's innovative. It's innovation. No, I don't fundamentally think you can copy what somebody else did for the first time and then pass it off as innovation. That's copying. You're a copycat. And so until and unless we come up with some idea of what is really the working definition of innovation and what do we want to promote, because if what we're going to promote are just a bunch of copycats, there will at some point in time be no innovation to copy. Now that's the extreme and not maybe likely, because what we're seeing right now is that they're small players are the ones who innovate. That's always been the case. And they innovate and then they get copied. And so they get to innovate once and they don't get to follow on and innovate more. And that I think is tragic. And that's why I think all of the stuff that's going on is by definition anti-competitive, because it's putting the true innovator out of business who can't possibly compete with a copycat, because the copycat can copy you and enter the market and not have to recoup any sunk costs, because there were no sunk costs for them. There were no cost of research and development. And it's terrible, and I wish more people would see through it. I think more people do see through it to see what's going on, and a lot of arguments that are made are just self-serving. I mean, what do you say about all that?
Well, I agree entirely, and I think what people miss, what does a patent do? The information is made public. All of the information underlying, because that has to be a step forward beyond prior art. That's the public patent file creates new public information. What does that do? It informs other parties about, first of all, how something was done, enabled, but it also gives them ideas about, hey, here's a new, for example, a new blood pressure drug. Here's a patent on it. Let us try and use a different molecule or something. Let's try and compete because we see a lot of sales going up. That party is benefiting. Here's something new, and let's try another way of doing that. And that creates competition. You get a new way of doing that. You get competing patents, and a lot of that happens. If you could just copy, where would the incentive to do the patenting in the first place? Because parties would say, well, we're not going to get a return. As we know, drug high risk, 95% of R&D pass, more or less, not maybe exact, fail. So you need to get a return when you have something successful. If you're not gonna get that return, if people are gonna cut copy your formulation, then why do it? So you're not gonna have you're depriving people. The other thing is, if their patents are not safe, they're gonna do more trade secrets. Trade secret problem is some of it leaks out, and then there's trade secret theft, but if it doesn't, the information isn't being made public. All sorts of information that could be used that adds to the corpus of technical and scientific knowledge is kept within the company, and that slows innovation too. And they don't even know, what they're competing with. And so that's another problem that, so I think they're on a variety of, and there's also evidence, as I say, the fact that sort of the economists call natural experiment. Look, when the Bayh-Dole Act, people complained about the fact that research was lying fallow, and even patents that could be obtained in university labs were lying fallow. Why weren't these great labs being used to get innovations? Well, the Bayh-Dole Act said, hey, you can come in, you have to give a license to the government, but you can come in and get a patent on research you have done. Suddenly, you had an explosion of patents and new innovations, which led major universities to get new sources of revenue, hundreds of millions of dollars, led to more building of bigger labs, led to more all sorts of innovations in biopharma and other areas. And that was clearly that what caused that. It's something that strengthened patents, that made a return to patents stronger, and because patents could be obtained now by companies that could not patent their work in a government lab. And there are other examples of that too. When patent law started being more flexible, fewer antitrust attacks on mere licensing, you had a lot of new licensing arrangements, pooling arrangements. Not all of them worked, some did, some didn't, but you had a great explosion in the rate of diffusion of innovation, and that's another big point that I think is off. There's an economist, a very practical economist called Dan Spolber, who teaches at the Northwestern Business School, who's written a book called A Case for Patents. He said, look, apart from just incentivizing, giving incentive to the innovator, patents create rights. As property rights, they can be bundled into contracts that can be licensed. Why is that important? Because licensing allows a diffusion. A license violation of contract, it can go after the violator, at least in principle. Uh, that allows a diffusion of innovation at a much faster rate throughout the economy, and it allows think of it allows innovations to be felt and change industry, create new demands, and that creates a huge amount of value. And he goes on at some length about that, and I think that's been proven true. I think it's no coincidence. We talked about correlation, causation. The sort of the great innovation. I mean, the transistor is what, 75 years old or so, but it really, it's in the last 45 years or so, period of greater licensing, of greater strength of patent and so on, that the incorporation of smaller and smaller transistors, into chips, and related innovations were driven. And a lot of that came out of licensing. And again, licensing is made more valuable through patents.
No doubt about that. And the thing that I also don't understand why more people don't get is that if you have a world, which we do right now, where the largest implementers in a lot of areas, for example, standard essential patents, they just will refuse to pay anything unless and until there's a court order or unless and until there's a real credible threat of an injunction, not in the US, because you can't get that credible threat of an injunction in the US. It has to be overseas now. And there are countries that do respect patents a lot more than we do here in the US. And they can get injunctions and that will break the logjam. But these largest implementers will use these tens of thousands of patents, large portfolios without paying anything for them. Then you have smaller competitors who are willing to license, who are interested in engaging, who do want the rights, they need the rights, and they can't afford and don't want to be involved in litigation. But if they take a license, they are immediately at a competitive disadvantage. And it just makes it worse. And it feels to me so clearly that the largest players in the industry who are refusing to pay the patent owners are the ones that are creating the anti-competitive aspects that we see, that we claim that we don't want. And it always rolls downhill. And it's always the small player, whether they're the innovator or whether they are the implementer, who winds up losing out in the long run. And that is historically not during my lifetime the US experience. That feels a lot more like the European experience, where you give greater benefits and deference to the largest companies. But here now, recently, it feels like we flipped. We're looking at a mirror where Europe seems to me, and maybe you'll disagree, I'd like to hear your thoughts on this, seems to be much more in tune with the SMEs, the small, medium-sized enterprises, and understands that encouraging them to grow is the way that you grow your economy. And we seem to used to get that in the US, but I don't think we get it anymore.
Right. Well, I think you have a good point. And ironically, Europe may be about to shoot itself in the foot here because of more and more talk within the European Commission and individual European states of you've had more and more studies, consultant studies looking at the supposed benefits of the eBay decision and saying, hey, wait, countries like Germany, it's too easy. We automatically issue injunctions. We should look at the wise decision by the US Supreme Court that limits injunctions, which would be crazy result, but maybe that would slow down the Europeans relative to the US if that is taken seriously. We'll see what happens.
Well, I can't believe that they would take that seriously. But having said that, I'm rolling my eyes because how many times in life do you see an entity, a company, a country, a group of countries, a continent have a head start and then they can't get out of their own way and they just shoot themselves in the foot? And that would be what that is. And because I do think it's funny though, because I think much of the rest of the world is starting to figure out that the Alice decision that makes it difficult or impossible to patent certain software. Well, hey, you know what? What is artificial intelligence? Well, at its very most basic, it's software. And it's getting harder in the US to patent some of that kind of innovation as well. And I think much of the rest of the world is starting to scratch their head and say, huh, thought Alice maybe was a good decision and that was a good way to go, but they seem to be pulling back on that. So it would just be odd for them to double down on eBay when it is so catastrophic. It has been horrible. I mean, look, I think the law works best, and this is an economic view of the law. The law works best when parties can get into a boardroom, close the door, and come out with a agreement that both parties can live with and move on. The law does not work well when it forces people to litigate. And in the patent world, over the last 15, maybe 20 years, increasingly the law has forced people into the courtroom and out of the boardroom. And that just creates a mess.
Right. For instance, the settlement of what is a good fair, reasonable, non-discriminatory rate. That should be made through negotiations. There are lots of studies that suggest that. But the problem is that you've had lots of foreign courts and U.S. courts now, but more and more, the foreign courts are competing, saying, "Well, we're going to establish a FRAND license rule for this particular patent or this particular set of licenses because it should not be unfairly high." But by doing that, as I say, you just encourage more litigation. In fact, litigation moves from one place to another, and you get fights over can you enforce this FRAND rate. It would be much better if they allowed negotiations and said, look, if you don't come to an agreement quickly, we can get an injunction. If you get injunctions quickly, people come to the table and they settle these things instead of getting into fights. And of course, what's the outcome if you have a lot of court decisions around the world weakening the returns on FRANDs? Again, this matter of logic, I think, is you're going to get less investment by parties engaging in standard setting organizations and negotiations, because why put up your technologies if they're going to get crushed down by jurisdictions around the world? So that's another reason that, as you say, it's a focus on getting parties to the table. And there are lots of, I think, economic studies say judges are not experts in determining what is the optimal rate. There are all these tests out there, but optimal rate, I think, in market economics would say is a matter of of the subjective values of the parties at the bargaining table, and they can come up when they come up with an agreement. That's going to be a better result than something a judge with limited information comes up with.
Absolutely. And there's also a big piece of this, I think, that is owed to the fact that there is a certain level of counterintuitiveness that goes on here. And I'm reminded by the whole Bayh-Dole, which you mentioned earlier. I had an opportunity to speak with Senator Bayh after he retired and towards the end of his life with some interviews and looking back on what they did and why they did what they did. And he said, I got at the time why people were skeptical about this, because the argument that the federal government has paid for this research on some level, at least provided seed money to get the research going. So the patent rights should be owned by the federal government. That's sounds logical, right? The problem is that it led to zero licensing. Nothing that the federal government was funding through universities was ever getting licensed. It was just wasting away and nobody would invest in it. And so he said, well, if what sounds logical isn't working, then let's try something else. And it worked enormously. Bayh-Dole is the most successful piece of legislation, according to The Economist, economic piece of legislation since World War II. I mean, it's led to so many companies and jobs and cures and treatments. But there does seem like there's this counterintuitive aspect of patents that harkens back to that. And by that, what I mean is, if you really, really want to incentivize innovation, you should have a patent right that is extremely strong, no fair use, hard to break, strong injunctions, because if you can prevent other people from doing it, then they're not likely going to just throw up their hands and say, oh, well, we lost the race, we're going to give up. Creative people are going to try and find creative ways to get around what you've patented so that they don't have to violate your patent, so they don't have to pay a license to you. And then they're going to push innovation forward by trying to get around and research around and innovate around. But when you have a weak patent system, there is just no reason to innovate around. You just take. And when you take, you're not contributing, you're not innovating. So I would rather have a patent system that is extremely strong than one that is weak, because the weak patent system does not lead to more innovation, leads to more copying.
Right, and I think that's something that is not appreciated. As you indicated earlier, it's one thing the Europeans seem to appreciate, and but perhaps not. Again, the point about inventing around is exactly as I said. That's what I think we're already discussing. The fact that more technical information gets out into the world quickly because of the nature of the patent law, and making that information public but protecting the party who gives the information, as I said, the best of all worlds. It gives the incentive to get a return on that, but at the same time, as you said, it allows people to figure out okay, this is one way of doing this. Let's look at other ways that might produce a similar product or process and so on, and or something better, and it compounds. And I think that point doesn't get driven home as effectively as it does in the public sphere. Partly it's because, one of those problems is it took many, many years for the 2011 American Invents Act to come out, which had lots of problems with it. I think because it created boards that allowed periodic and serial attacks on patent rights on patents that had been issued. I think that's being curbed a little bit by the current patent office. But why did it take so long? It's because you had groups that benefit, companies that benefit from trying to free ride on somebody else's patent rights and wanted to minimize the licensing fees who were opposed to legislation. One of the natures of Washington, lobbying and counter lobbying, and because whenever you have concentrated economic interests who want to get cheap technology, it's very, are going to lobby, and that's makes it very, very difficult to get good legislation through Congress. This is why, as I say, it's frustrating because if the Congress could merely do a couple of simple things, like basically restore the pre-eBay rule presumption, and just, in a simple way say, "No, all the Supreme Court decisions that added non-statutory exemptions to what is to patentability, those are gone." You could 2 simple things could, I think, really unleash a lot more innovation than you have now, but it's having worked with people who have tried for years and years and years to do a couple of things along those lines, it's frustrating.
It's a heavy lift. It's a heavier lift than it should be. I've written for years that I think the three problems with the modern patent system are: one, eBay; two, the eligibility decisions; and then three, the PTAB. And we've got some relief from the PTAB, at least administratively at the USPTO. Things are moving in the right direction under Director Squire, started by Acting Director Coke Stewart when she got in right away. The Trump administration was trying to solve that, and they continue to, I think, move in the right direction there. Still more to be done, and it would be great to get those reforms codified. But PARA, which is the eligibility reform, that just has stalled and going nowhere, unfortunately. And at least we're talking about it, I guess. So maybe hopefully at some point that'll get resolved in one way, shape, or form. And then now, again, we do have, at least on the administrative level, we have the Department of Justice advocating for at least some kind of a change in the eBay, maybe not the eBay standard, but the way of thinking is that injunctions are not bad per se. So it does seem like we're talking about all of those three things that I think have been the modern blight on the patent system from the patent owner's perspective. But boy, it is frustrating how long it's taking to get anything done on those issues.
Yes, yes. This bipartisan effort, the director, Capos and director Iancu they've tried hard and they need to hopefully keep trying. It's great that you have very successful heads of the Patent and Trademark Office, one under Obama administration, the other under the first Trump administration, who have made common cause and are singing from the same song sheet. You just need to part of the problem is the general public, it seems to be a very wonky issue when people accept the great political focus and nowadays on lower prices, like cheaper prices. Why do drugs cost so much? Why are the Europeans paying less? Well, there are answers to that, and part of it may have to be international negotiations to get them to pay more, and American consumers indirectly are sort of subsidizing foreign consumers because the pharma patent holders and biopatent holders have to get a return from somewhere to invest. So solving that problem is going to be very important. But price controls are the worst possible thing. The after the Inflation Reduction Act and additional things threatening more price controls on drugs, price controls as any economists, one thing where economists do tend to agree, price controls are bad. They create shortages, but they create strong disincentives for investment in new products because uh, why are you going to invest in something when you're not going to get the return necessary to cover your costs? And that's what price controls do. But explaining that you are missing out on all sorts of new drugs or the availability of drugs in the abstract is sometimes a hard sell to the public, I think.
It is, but the fight goes on, and you've been a great ally in this fight on the competition front. I hope you continue to stay active, like I know you plan on doing.
Well, thank you, Gene, and I think it's important to keep pushing, emphasizing the positive things that are being done here by, I think, our antitrust forces that are pro IP, and to try and convince the Europeans, as we've already suggested, stay away from eBay, but also be supportive of innovation. And Europeans have an incentive. They had a big report come out by a former head of Bank of Italy that everyone quotes in Europe, Draghi report, it's called, that says we need to innovate more. Well, what's the best way to innovate more? It's to have stronger patent rights. And maybe if they can be convinced that one reason innovation fled to the US decades ago was that because their patent rights were weaker. And if everybody can be convinced there are real economic benefits in driving innovation in Europe, what you're trying to do, as well as here, and if the tie with patent rights can be understood, that would be a great result.
Absolutely, absolutely. So I will just also let people know that Alden has a weekly column on truth on the market. You can go to truthonthemarket.com. He writes about antitrust almost every week. And hopefully we'll get you to write a little bit more for us, Alden. I'd love to share your thoughts with our audiences as well. And I really appreciate you being here today. Thanks for coming.
Well, thank you, Gene. If I could only clone myself, then I'd have even more time to write about IP, but that's a separate conversation.
Thank you for listening to IP Watchdog Unleashed. We will be back next week, and we hope you will join us again. In the meantime, please be sure to visit IPWatchdog.com to read all the latest news and information about what is happening in the intellectual property world. And also be sure to subscribe to our free daily email newsletter.